Hello, everyone. I hope you're having a nice Memorial Day weekend so far. I'm taking the opportunity to make a video about the lecture for this next week. And in this week, we read the John C. Paulus article that discussed an outline of Finder's Law. So I hope you enjoyed this article, and I hope it tied the room together, if you will, bringing together a lot of loose ends from some of the cases that we read and settling a lot of questions. In this video, I'm going to tell you about how the common law traditions of both England and America have led to the creation of different rules that you'll need to be aware of as we have an eye toward the first writing assignment. So in this video, I'm going to explain to you what the rules are that you'll need to be familiar with. And then the next video, I'm going to show you how I would work through some of these problems as a way of looking forward to the kind of writing that you'll be doing on the first writing assignment, which will go live on May 31st. Recall that if you have any questions about this writing assignment, I'll have this Friday discussion section, not only in the coming week, but the week after that. And so there will hopefully be plenty of opportunity for you to come to ask me any questions you have. And hopefully we can work out the answers to some of the questions you might have. But for now, I have the more limited focus of looking at the rules of England and America as they pertain to Finder's Law. So that's what we'll do today. Now, John C. Paulus gives us this summary of the law today, and I'm just going to read it to start off this video. He says, the owner of the locus in quo prevails over the finder if the latter was a servant of such owner and had the duty to turn over found goods to him. Clause 2, except as provided in paragraph 1, the finder prevails if the goods were abandoned. Clause 3, except as provided in paragraph 2, the owner of the locus in quo prevails if he was in a fiduciary relationship with the probable loser at the time the goods were lost or misplaced. And then clause 4, except as provided in paragraphs 1, 2, and 3, the finder prevails if the goods were lost, and the owner of the locus in quo prevails if the goods were mislaid. The remainder of Paulus's article, as well as the remainder of my lecture today, will explicate this outline, which is an outline of the rule in America. The rule differs in England, and it's good to flag this. But I think what I'd like to do for you first is to put this summary that Paulus has given us into more plain English. So here's my preferred statement of the American rule. This is the rule that applies in America, American jurisdictions, right? The American rule is that the finder of lost or abandoned property acquires superior title to the entire world except for the rightful owner. But if the property is mislaid, the owner of the locus in quo acquires superior title to the entire world except the rightful owner. That's the rule in a nutshell. And then we can note two exceptions to it. The first exception is that there is a pre-existing contractual relationship that provides for a finder to turn over anything found to the owner of the locus in quo. I prefer to put this in terms of contractual relationships rather than master-servant relationships, because you may have been misled and might have thought that there was just some antiquated, kind of servant-master relationship that was at play here, when in reality it's something more simple. It just depends on a contract in which two people might contract for something to happen. If you write a contract with somebody who's hired to come over and clean your attic, and you say in that contract, by the way, if you find anything in the attic, I'd like for you to turn it over to me. And that's a condition, by the way, of my hiring you to do this job. If there is a contract like that, oral or written, it's an exception to the American rule for Finder's Law. Now, the second kind of exception that applies in this case is going to be the existence of a fiduciary relationship. So exception 2 is that the owner of the locus in quo was in a fiduciary relationship with the probable loser. Throughout Paulus's article, we learned that this is more and more restricted than we would have thought. This exception applies only to relationships where the owner of the locus in quo is thought to be in a position to make his clients better off financially than they were when they came through his doors. We already saw one example of this earlier in the case of Bridges versus Hawksworth. This was the case of the innkeeper with his clients. The innkeeper is thought to be responsible in some way for making sure his clients or his guests are just as good as when they left the door as when they first came through his doors. He bears a special fiduciary responsibility. Likewise, we saw that the owners of banks bear a special responsibility to their clients to make sure that their clients maintain the same economic position as when they left, as when they came in. I'm not sure if I'm saying that exactly the right way, but you get the picture. I mean, these bank owners and these innkeepers, they have to maintain the status quo. They have to keep you just as good as you were. And because of the existence of these special relationships, property found in inns and banks, for instance, would go to the owner of the locus in quo and not to a finder. But as we find out in the Paulus article, this is even more circumscribed than I've just let on, because it's only those private areas of a bank or those private areas of a room, of an inn, such as a room, to which this exception would apply. For instance, if you find a bundle of bills in the lobby of a bank or in the lobby of an inn, it seems like the finder would still prevail. But if there's some area that's not accessible to the public, an area like a room or a bank vault, then it still seems like the property found therein would go to the owner of the locus in quo and not to the finder. So obviously this rule that I've just read has a few terms that as of yet have not been explicated. And I'd like to do that in just a moment, but let's think one more time about what the general rule is for America. It's that the finder prevails if the property is lost or abandoned, but the owner of the locus in quo prevails if the property is mislaid. They prevail over the entire world except for the rightful owner. So obviously now there are some terms that need further explication, aren't there? We have these notions of lost, abandoned, and mislaid property. So let's think about what each of these terms mean. These are all defined, by the way, in the Paulus article. I'm going to give you my gloss as well with some examples. Suppose you're walking in an amusement park and you reach into your pocket to pull out your phone. But when you do so, you also inadvertently pull out your car key and it lands on the ground and you walk away, never knowing that you dropped it. In this sense, the property is lost. Lost property is property from which the owner is unintentionally dispossessed, and it's usually by dropping, but it needn't be by dropping. So if you were the same person in the same amusement park, but your car key was in your pocket and you later went on a roller coaster and the roller coaster threw you around and the key flew out of your pocket while you were on the ride, well, you didn't drop it in any sense of the term drop, but you still lost this thing because you were unintentionally dispossessed of it. In other words, it left you in a manner you knew not how or when. And although we're usually unintentionally dispossessed of things by dropping them, it's not always the case. Sometimes they might fly out of your pocket. But usually, when we use the term dropping to describe the way in which something is lost, this is going to fall under the legal category of lost property. Let's contrast this with a different kind of case. Suppose instead that you're at an airport and you take out your wallet and you put it on the seat next to you. In other words, you've intentionally placed your wallet in that place, but then later suppose that you just forget about it. You walk away or something calls or the flight is boarding and you frantically get up and just leave the wallet where you intentionally placed it. American law treats this as a different kind of losing. They call this category of property mislaid property. You've mislaid the property because you've intentionally placed it somewhere and you've forgotten about it. And recall that under the American rule, this is essentially the greatest difference on which all these cases will turn. If the property is mislaid, if you can tell that the property has been mislaid, then the owner of the locus in quo will prevail over a finder. But if the property looks like it's been lost or dropped, or it looks like the person has been unintentionally dispossessed of it, it's more likely that a finder will prevail. Okay, there's one last category of property, which is recognized by American courts, and it's the category of abandoned property. This category of property is the category in which the item, by the conditions under which you find it, provide evidence that the previous owner intended to permanently relinquish any possessory interest in that property. I think usually of what happens when you live in an apartment complex and you see a lot of stuff by a dumpster. Sometimes you see really cool stuff by the dumpster: coffee tables, chairs, mattresses, games, lamps. You know how it is when you move out. Sometimes you're just so desperate to get all your stuff into the car. It's more convenient for you just to rebuy those lamps and chairs and coffee tables than it is for you to make a different trip to the store altogether. A different trip back to the apartment to get those things that you had in your previous apartment. So whenever students move out of their housing, there's always a ton of stuff that accumulates by the dumpsters. And that's property, which, under the conditions in which one would find it, provide evidence that the previous owner intended to permanently relinquish possession of it. So stuff that's thrown away looks like it's abandoned. And when the conditions under which the item is found provide that kind of evidence to you, the court will be more likely to classify that kind of item as abandoned and not mislaid and not lost. So we have these three categories of property recognized by American law. You have lost property, unintentionally dispossessed, usually by dropping. You have mislaid property, intentionally placed and then forgotten about. And then you have abandoned property. It's just property which, from the conditions under which it's found, provides you with this evidence that the previous owner intended to permanently sever all possessory interest in that item. Maybe you could pause the video and try to think of your own examples about these categories of property. But in American law, everything hinges on the categorization of the property. Very little depends on the other facts of the case. Of course, there are these exceptions that I've told you about. There could be a pre-existing contractual duty that was established, or there might be this special fiduciary relationship. The owner of the locus in quo might be the owner of a bank or an innkeeper. But if neither of those situations apply, then usually what's going to happen is that the finder will prevail if the item is lost or abandoned, and the owner of the locus in quo will prevail if the property is mislaid. So if there's some evidence that the previous owner, intentionally put the item where it was found, the owner of the locus in quo will prevail. Now, there are some policy considerations given for why the American law has become what it is. I'm not going to pretend to you that they're the best in the world, but a lot of people will often say that the American law is this way because somebody that intentionally puts the thing where it's found is more likely to remember where they lost it than somebody who has been unintentionally dispossessed of their property in a manner they knew not how or when. One who intentionally puts their item where left might more likely remember where they put that thing. And so the law favors keeping possession of that thing with the owner of the locus in quo. And so it makes sense why the owner of the locus in quo would prevail over a finder. Now, of course, I don't understand why that's the case, because you might just think there could be a statutory period, say 2 years or something, where the owner of the locus in quo would have possession, but not the best possible interest in the property. And that after the statutory period, the finder could prevail. I don't understand why that isn't a sensible solution either. But a lot of people will at least reply to you that the American law makes sense because it's more likely to reunite mislaid items with the true owner. Whatever you think of that, I'll leave it up to you to think about the merits of the law. I'd like to turn my attention now to the way our brethren across the pond approach these problems. And let's look at the English rule, which differs slightly from the American rule. Now, the English rule does not recognize the existence of mislaid property whatsoever. So please understand that right now. In England, it does not matter if anything was intentionally placed and then forgotten about. They don't recognize this category. It plays no role in their legal reasoning. It doesn't exist for all intents and purposes. The English rule, however, does make a lot the distinction between how many steps were taken to ensure that nobody else came to the locus in quo. And so let's look at the English rule now. The English rule is that a finder of lost or abandoned property acquires superior title over the entire world except for the rightful owner if the locus in quo is public. But if the locus in quo is private, then the owner of the locus in quo acquires superior title. Now, in this rule, I've actually made mention of mislaid property. That's just because I want you to know that it doesn't matter in England. All that matters is that the locus be public or private. So clearly, in order to understand the extent and the application of the English rule, we now need to understand these terms that I've put in red, public and private. And I'd like for you to take away from the Paulus article the notion that private loci are those where the owner has manifested an intention to exclude others. So the case of South Staffordshire Water Company versus Sharman lent some support to this proposition, because in that case, the water company took these pains to exclude everyone else from coming to their pool, presumably by putting up fences and gates and that sort of thing. Likewise, in Hannah versus Peel, we have kind of a negative example about these classifications, because what's going on there is that there is a landlord-tenant relationship in which Hannah was allowed to be in Peel's estate. And so it looks like if the finder, in other words, is rightfully in the place where he finds the property, then it looks pretty unlikely that the owner of the locus in quo will prevail. Think, by the way, also of Bridges versus Hawksworth. The shop was public because it was in normal business hours. If, however, Bridges had found the notes in the shop of Bridges versus Hawksworth after hours when he wasn't supposed to be there, then if pains had been taken to keep out the general public, either by locking a door or making some other explicit measure to prevent the general public from coming there, then it doesn't look to me like Bridges would have prevailed in that case. And so in England, all they care about is looking for evidence that someone was not supposed to be in the place where the item was found. All right, so just think of all the different ways that someone could make their property private. The owner of a manor paradigmatically has privacy in that residence. And so that explains this discussion in Bridges versus Hawksworth about the manorial right, that it explains the intuition that you can't just come to somebody's house and find property that's been lost therein. Meanwhile, if you find property in a public place, it seems like you're perfectly within your rights to claim ownership of that thing against the entire world except for the rightful owner. All right, so just in summary, the American law places great emphasis on the category of the property that was lost. How was the property lost? This is the main question with which American jurists will be concerned, isn't it? If the property has been intentionally placed and then forgotten about, the owner of the locus in quo will acquire superior title. If it's property that just looks like the previous owner was unintentionally dispossessed of it by dropping it or by flying out of their pockets or by some other reason, it looks like the finder will prevail. And a finder prevails when abandoned property is found too. No, and I guess I should say in English, under the English rule, the finder of abandoned property will also prevail as long as the locus is public. We've just been focusing on lost property, but in England, the results differ greatly because they don't care about how the property was lost as much as they care about whether the owner of the property took these pains to exclude the public, whether they manifested some intention to exclude the general public. And the more it looks like the owner tried to keep people out, the more it looks like the owner will prevail. But if there's any chance that the finder is rightfully in the place where the thing is found, it looks like the finder will have a better claim to that item that was found than the owner of the locus in quo. That explains the result in Hannah versus Peel, because Hannah was a tenant in a house. He was rightfully there. But you might think that there might be a landlord-tenant relationship in which the tenant occupies one part of a building in which he might rightfully occupy and find things therein and have superior claim to the owner. But you might also imagine that the owner lives in, one room or something like that. Of course, the tenant couldn't go into the owner's room and then have good claim to the things found therein. It has to be more or less a place they're allowed to be within the place they're renting. It has to be public to them. So that's the English rule. The English rule is that the finder will prevail if the locus is public, and the owner will prevail if the locus is private, where privacy is defined by this manifestation of intention to exclude others. The last thing that's worth mentioning is that at the very end of the Paulus article, you're going to see an alternative rival outline that's proposed. And the alternative rival outline is replete with mention to all sorts of controversial things that Paulus thinks are not well-established law. And so if you ever get stuck in the next writing assignment and you're trying to figure out what the law is, and you remember something that's said from the Paulus article, do not go to the end of the Paulus article, because more often than not, students will end up confused. They see this other outline and they often assume, oh, that must be a restatement of the law. And so they start using trespasser rules and such in their writing assignment. And they're on the wrong track, because that is the outline that Paulus rejects. So he wants us to think that there are a few red herrings that we would do well to ignore in any discussion about who has superior title to lost property that's found. We never need to talk about treasure trove, at least not in America. In England, you might need to, because they have rules about the government getting treasure trove. But here in America, we don't care whether something is treasure trove. We don't care about that legal categorization. All we care about is whether it's lost, mislaid, or abandoned. Another thing that we don't care about in America is the trespasser rule. Now, it does seem somewhat intuitive to me to say, if you trespass onto somebody's land, you don't have finder's rights. But that isn't the law, actually, in America. It's not really why in Goddard versus Winchell, Peter Hoagland doesn't have this great claim to the meteorite. Peter Hoagland's claim wasn't denied, or Winchell's claim wasn't denied. Peter Hoagland was a trespasser, it looks like, in some way. He was kind of digging around on the land without the owner's permission. But that's not why he was denied title to the meteorite. He was denied title to the meteorite because it became part of the realty through accretion, right? So don't be fooled by the trespasser rule. This idea comes from a very old case in Massachusetts in which somebody actually was denied title to property that they found on the basis of their trespassing on the place where they discovered the item. But that was a very old case, and it doesn't seem to have gained any momentum in American law, and nobody appeals to it as case law today in their reasoning. And so don't be misled by the trespasser rule. There is no such thing in America. Likewise, there's not really enough idea for there's not enough support for the idea that chattel, that is personal property like a guitar or a telescope or something of that kind, could become embedded in the soil and therefore become part of the realty. The only case we read that lent some support to that proposition was, I believe, Yules versus Brigg Gas Company, in which they found a canoe. And the judges were sort of hedging in that case. They said, we don't know exactly how the lessor has these rights in the canoe. It's either because the canoe is a mineral or because he owns all the chattel in the land. But that's the only kind of support we get for the idea that chattel could become embedded in the soil. It just seems like, but at the same time, it does seem like this is kind of the rule that they advocate in Goddard versus Winchell. So I'm conflicted about what to think here. It does look like in Goddard versus Winchell, Goddard's lawyers say something like, no, Goddard owns the meteorite because he owns everything that's in the soil. And that is what his lawyers say, but I'm not sure if the court ultimately adopts that as the reason why the meteorite was his. They seem to say that the meteorite's his because it's more like accretion. So I'm sympathetic to that distinction. It's very subtle, and you might be frustrated by that just as I am. But Paulus at least rejects the idea that something could become the owner of the locus in quo just by becoming embedded in the soil, right? So he's skeptical about that conclusion. Now, it might very well be the case that uh, a court would in the future rule on that basis, but there's not very much support for that idea in the law. If you were to derive some kind of support from it, you'd be looking at Goddard versus Winchell or Yules versus Brigg Gas Company. But the support for that idea is weak. So in sum, the red herrings that you will want to ignore are treasure trove. Nothing will ever depend upon this. The trespasser rule, that is not a rule in America. And although it's very tempting to think that chattel could become part of the realty, and though it does seem like Goddard's lawyers heavily urged the court to adopt this as a rule, it's not clear whether the court in Goddard versus Winchell does it. They do seem to rule on the basis that the meteorite became part of the land on the basis of the doctrine of accretion, not because it's a chattel that is a little piece of personal property like a cell phone or a cup or something like that, that could become the owner's just because it became embedded in the soil. So maybe another way we could try to draw out this distinction is between natural resources which accrete and chattel which does not accrete. Again, a piece of chattel might be, a cup or a cell phone. And if the cell phone is embedded in the soil, it's not clear that that would become the owner of the locus in quos. Contrast that with a boulder that rolls down the hill and does become embedded in the soil. You might think that the boulder becomes the owner of the locus in quos because of the doctrine of accretion. So that's probably the best way to understand the result in Goddard versus Winchell. It extends to perhaps natural resources that become embedded in the soil. It might not extend to personal property like cell phones and cups. So that is the confusing, but hopefully somewhat elucidating answer to the differences between the English and American rules. You now need to master 2 rules. And of what significance will the rules be for you? Well, recall to you that I've been teaching you this format called IRAC. It's a format of legal writing that I'll expect you to exhibit some proficiency in on the next writing assignment. What one does when one writes in IRAC format is they begin with a very clear statement of the issue. What is the issue? Well, in the cases we've been studying, the issue is usually who has superior title to something that's found. Is it going to be the finder, or is it going to be the owner of the locus in quo? That's the issue. Now, the rule statement will require some judgment because you'll have to figure out the jurisdiction. Usually that should be clear from the facts. The facts will usually tell you whether something happened in America or in England. And so you can, based on the facts, pick the rule that's more relevant. Now you know what the rules are. You know the American rule, in which the court will be most interested in whether something is lost, mislaid, or abandoned. And you know the English rule, in which the court will be most interested in determining whether the locus was public or private. After you state the issue in the rule, you can read a fact pattern, that is to say, a little story about something that's happened legally. And you can make arguments about, how the item was lost or whether the locus was public or private. There will be facts in those kind of patterns that jump out at you. And you can make arguments about whether the court should think that the property was lost, mislaid, or abandoned. Or if you're in England, you can make arguments about whether the owner has manifested a clear enough intention to exclude people from a certain location, right? Those will be the way, that'll characterize the way you'll predominantly want to approach these legal writing problems. But in the next video, what I'm going to do is look at a few legal stories, right? I'm going to show you a few fact patterns, and then I'm going to systematically go through and I'll approach, the fact pattern as though I were writing an IRAC answer to it. And then hopefully by the time I do that, you will have seen how I expect you to proceed on the writing assignment. So in the next video you see for this week, which will likely be posted tomorrow, I'll show you how to write legally. I guess that's the best way to put it. So with all that being said, that's all I'd like to say for today. You now have the rules you need to start doing some legal writing. And in the next video, I'll make a nice video showing you how to do all of that so that you can approach the writing assignment with confidence. I'll see you in the next video.